Hello everyone, my name is Dr. Ruthy Lowenstein-Lazar, and my talk today is about a group of women, older women, who are victims of sexual violence but are almost invisible in legal research, in legal activism, and in the criminal justice system. My talk is based on a research that explores a topic that has been neglected in legal scholarship and offers a new empirical legal account of sexual violence against older women. To achieve this end, I have searched more than 1,000 American cases. The final empirical basis includes 107 cases describing some form of sexual violence against women over the age of 60 between the years 2000 and 2018. I will introduce some of the findings and will share with you some of my thoughts regarding these findings. The full research is going to be published in the Michigan Journal of Gender and Law. The main picture that we see is the stranger rape scenario. 68% of the cases introduced rape that was perpetrated by a stranger, usually in the context of home invasion, battery, and robbery. The majority of the cases include extreme and brutal physical and sexual violence, so brutal that 28 victims of 147 victims died as a result of the assault compounded by their age. Only 12% of the cases introduced acquaintance rape. Only 18% of the cases introduced rape in institutional settings perpetrated by another care provider or another resident. Not even one case of rape that was perpetrated by an intimate partner. So what does this picture tell us? What are the cases that get to court? Or more importantly, what are the cases that do not make the ways to court? The main cases, the cases that make the way to court, are the stranger rape cases. Why? First is the existence of physical violence. Physical violence provides corroborative and physical and very strong evidence. That way, these cases are easier for the prosecution to proceed to court. They are not a word against word scenario. Second, the power relations between the victim and the offenders who are much younger and stronger than them. The third reason is the fact that rape myth and stereotypical perceptions of rape and rape victims are just not part of the picture. We do not suspect these older victims to provoke the sexual violence in any way. Consent is just not part of the discourse. So these are various reasons for the dominance of stranger rape cases in courts. Conversely, rape in institutional settings is hardly noticed. Why? Well, many of these victims suffer mental, physical, and physiological disabilities. They have a hard time verbalize what has happened to them. They have a hard time saying no to the sexual assault. There are no witnesses to see the sexual violence, and these victims do not have a voice to make in court. Rape by an intimate partner, although it is the most prevalent form of abuse in criminological and sociological and gerontological research, is just not visible in the legal picture of sexual violence against older women. It is underreported, underprosecuted. So despite findings indicating that sexual violence against older women creates serious consequences and is a serious human rights violation, it is hardly noticed by health professionals, social workers, legal professionals, and society at large. It is being noticed when it fits the real rape scenario, when the victim is the ideal victim, frail, innocent, very old. But what about the other cases that are not noticed by the criminal justice system? Scholars and policymakers should consider the interplay between age and gender in framing this phenomenon, conceptualizing it, and treating it accordingly. There is a need for a holistic approach to sexual violence against older women. There is a need to provide legal and social mechanisms to these women that will fit their needs both as women and as older victims. Thank you very much.